The surveillance of Andre McDonald on the morning of March 2nd before he left, and as he's leaving Solitude Cove to go to Nagel's, and then the gate code logs, which I'll be discussing.
So I heard you right, there's no further witnesses, just the exhibits you're offering.
That's correct, Your Honor, and then we will proceed to argument. And we'll, of course, want to make our bill with respect to the Franks issue, but we can do that at the court and the court reporter's leisure. There being no objection, we would.
Sorry.
You can hold the.
Depends on compensate, but I'm missing. I mean, 33, 30. State, I mean, 17, 18, 19, A, and 22. I was missing a few exhibits.
Okay.
I don't know if he's got them somewhere up there, or if y'all have them on your desk. For y'all, it's 33 and 34.
Okay.
And then for y'all, the judges on
I don't see them in my file, but I can look after the hearing through the file.
Thank you, Judge. Make sure that these.
Well, you know what? Oh, that works so good here.
It was 33 and 34.
33 is, I have wrote down Smith's statement, and I think it's Gonzalez's statement.
Okay. I'll double check. One of those may have been just marked for identification and not offered, but I'll have to double check.
Maybe you can check on the record too to see if they were just identification not offered.
Okay. Did y'all often send them to you? Because I know sometimes y'all just are marking them and they're all saying no objection, but nobody's like really saying.
I hope that I've offered everything, but you know, in the heat of the moment, sometimes I forget. We'll make sure. I'll go through the file.
Let's see what we got now. There's no objections on 41, 42 defense, and 43, 6.
This day has no objection, Your Honor.
Okay, very good.
Thank you, Judge. With that, you know, we don't anticipate presenting any other evidence. We would remind the court that the issues that are outside of the Franks v. Delaware standard are either going to be argument on the papers of the four corners of the warrant, or they're matters that the state carried a burden.
How much time do you need to argue?
So, I mean, the court has our briefing before, and I think we can summarize it fairly quickly. If you could maybe give me 15 minutes.
Okay, that's what I was thinking. That's something we have to go through this whole thing again, but I've heard everything. I've got all the briefs. That's fine. We're going to start.
Yes.
And I'll just put it this way too. Instead of you going and hearing a response from you and then going back to you and then going like that for an hour, I'm just going to do 15, put it all out there, 15, put it all out there. Yeah.
Okay, thank you, Judge. Your Honor, this case starts with a warrantless trespass by a private citizen, and it's Under 3823, that action is plainly reachable by the Texas exclusionary rule. There can be no question that it's a trespass. There is clear evidence from Carol Gambar that her intrusion that morning was not by permission or consent, that she was not invited into the home, that she does not have any kind of standing invitation or license to come into the home whenever she pleases. The front door of Solitude Cove was locked when she arrived. There was no evidence outside of the home that would give her any independent reason to believe that something was wrong. She trespassed into the backyard of the property, which was fenced in its entirety by what she believes to be about a 6-foot wooden fence. She then walked in through a back door, which was unlocked, and proceeded to go into all manner and variety of nooks and crannies within the McDonald home, including their master bedroom and bathroom, where she discovered this evidence that caused her so much concern. That is, without a doubt, under those circumstances, a trespass. Ms. Gambar also testified that while she has been to the McDonald home many times, that she doesn't come in when she's uninvited, and that every time in the past that she has come in, it was expressly with the understanding of the McDonalds that she's supposed to be there. None of those circumstances are present here. Under 3823, the Texas exclusionary rule, that is a very simple case of both criminal and civil trespass, and under that standard, it has to be suppressed. We've also, out of an abundance of caution, although I think it unnecessary except in the grandest of constitutional senses, it's also a true Fourth Amendment violation, because we have evidence in this case that Carol Gambar notified a San Antonio Police Department detective, Brian Ray, and advised him about what she saw, and that he gave her instruction as to how to proceed from there. He instructed her to leave the residence and to go get Maureen Smith, the mother-in-law. Now, in the context of Brian Ray's testimony, we would ask the court to hold very little weight to some of the assertions that Mr. Ray made, as the court, I think, could plainly see, and I think we were all getting a little frustrated with him. Mr. Ray was extremely reluctant and hesitant to answer questions, was a very combative witness, and clearly has an agenda, partially driven by the fact that he knew the McDonalds and knows Carol Gambar very well. Also, we would point out, Your Honor, that because Brian Ray's testimony indicates that his phone was destroyed, although in other correspondence with the district attorney's office, he made it clear that he just simply didn't want to give over his phone, despite the fact that he knew it contained statements of witnesses in this case, and that information is no longer available. And we've been unable by any other means to acquire the full content and extent of his communications with Carol Gambar. We would ask that the court draw an inverse inference from that under Arizona versus Youngblood. We believe that that is a willful and deliberate destruction and occlusion of material evidence in this case perpetrated by Brian Ray. That isn't to say that this is the district attorney's fault, but in the way that it's operated, we have been unable, through our right to compulsory process, to acquire this information. And the way that Brian Ray has interacted with the district attorney's office suggests to me, at a minimum, dishonesty, and at a greater extent, a desire to prevent this evidence from coming to light, and that we should interpret that evidence in the light most favorable to the movement, to the defense. What I would ask the court to draw that inverse inference to is that Brian Ray directed Carol Gambar to do these things, because any homicide detective with that much experience and training would understand that what Carol Gambar was describing are the interior contents of a crime scene, where she is not rightfully or lawfully in a position to view that evidence, and that her presence there jeopardizes and compromises the integrity of the entire investigation that might follow, and that curative steps have to be taken. And Brian Ray is giving her those directions by taking her to go get Maureen Smith. We believe that that is an adoption by law enforcement. We believe that that is a direction by law enforcement. And therefore, that this isn't really, truly, just a private citizen search, 3823 aside. That there is obviously enough police involvement from the beginning that we can construe this as a Fourth Amendment violation, and Carol Gambar and Elizabeth Cancel as extensions of the state of Texas for that person. The law on this seems fairly clear. The government can't, if the government adopts more than a purely passive position, which would include giving instructions and telling people how to behave, our submission is, under Skinner versus Railway Labor Executives Association from the United States Supreme Court, then it does create a Fourth Amendment question, irrespective of the fact that the person's a private citizen, and irrespective of the fact that Carol Gambar may not have been on a crime-fighting mission when she first arrived at the house. The private citizen search issue is not attenuated by procuring Maureen Smith. I've been unable to find a single Supreme Court case involving third-party consent in which the third-party consentor has to be brought to the premises and is brought to the premises after the search has already been conducted in order to say grace over the conduct that has come before. But that's the circumstance we find here. If you hold that Maureen Smith's consent is valid third-party consent against Andre McDonald, I believe that we are extending third-party doctrine into a new arena from what we've presently seen in cases like Fernandez and Georgia v. Randolph, most recently from the Supreme Court, because that is an extremely unusual circumstance. Normally, what we're obsessed about in third-party consent cases is whether the objecting party is on the premises or off the premises at the time when the search is conducted. It's all focused on the defendant, his location, and his communicated belief about whether he wants or doesn't want police involved. This case really doesn't have any of those questions. The state spent a lot of time talking about, well, did Andre ever tell you to leave? Did Andre ever tell you you couldn't be there? That's a red herring, because the search has already happened. Two searches have already happened. A private search, a police search have already happened by the time Andre McDonald is even involved in this situation. And the reason why those searches occur is because we have police-directed intervention to go bring someone who might have the authority to give consent onto the premises. That is an extreme situation, unlike anything else that we have guidance on from the court before. And I think that under those circumstances, it would be dangerous to try and extend that holding to justify Maureen Smith's consent. But there are other reasons to doubt Maureen Smith's consent, one of which is voluntariness, which the state has a burden to prove by clear and convincing evidence. The court heard Ms. Smith's testimony. The court heard how confused Ms. Smith was about some of the more basic questions underlying this. I think that we can see that there is just generally a lack of understanding about how this process works, what her rights are, what her duties are, what her relationship to Solitude Cove is, given that she is a resident there, but she's not a property owner. She's there at the behest and the blessing of her daughter and her son-in-law. That's a unique situation in and of itself. She is from Jamaica, not as familiar with the American justice system as perhaps someone else is, or even American property rights as someone else is. There was some difficulty communicating in the course of both direct and cross-examination of the witness that might suggest suggestibility or things of that nature. But on top of those things, let's just look at the bare bones. This isn't someone who's at the property. Policeman knocks and says, "Hi, ma'am, I'm with the San Antonio Police, Bear County Sheriff's. May I come in?" That's not what we're dealing with. We're dealing with a situation where we can't really ever know what Maureen Smith's answer would have been, but for the fact that Maureen Smith already has been advised, as the consequence of an illegal private search, that there's blood in her daughter's bathroom, hair in her daughter's bathroom, and her daughter's not home, and no one knows where she is. Though that information has already been relayed to her. And so there is no attenuation of the taint from the original illegality by virtue of Maureen Smith's consent, because her consent is balled up in the very same illegal behavior that preceded it. And that affects whether we can take that consent at its face value. And in Fernandez, the court gives some discussion about the fact that the voluntariness of the third party is a legitimate inquiry for the court. I think under these circumstances, the state has not discharged its burden to prove to you, by clear and convincing evidence, that that consent was voluntary, as we expect it to be. So, for those reasons, the situation at Solitude Cove, as officers are beginning their search, their observation of this blood, is mired in Fourth Amendment and 3823 violations. And everything else in this case flows from those events. The warrants for Solitude Cove on March 1st and March 2nd rely heavily on this material. Heavily. The majority of their probable cause statements are tied up in these initial observations. We also have, of course, the Franks issues. While we've been unable to go behind the four corners and we renew our objection to being unable to do so, we believe that we have met the threshold showing to be able to demonstrate that several of the things that have been added to the search warrant are false, and that we have been able to demonstrate their falsehood. We know that Andre McDonald did go to Baptist Emergency Hospital, as he said he did. That his conduct on the day in question on March 1st was not consistent with flight or evasion. It was consistent with precisely what Andre declared he was going to do when he told them he was going to the hospital. That they knew that before this search warrant application was issued. And when we consider that in light of the fact that everything else in this warrant is dependent on an illegal search, we can recognize that it is essential to probable cause. That it is something that's material to the issuance of the warrant. And it allows us to go behind the four corners. When we do that, the court gets to consider all of this as a reason why the warrant shouldn't have issued. The police.
You have about 3 minutes.
Thank you, Judge. That applies with equal force to the second warrant as well, with the added concern that in the second warrant we have this renewed unlawful search, warrantless search, after the scene has been cleared, that occurred on the morning of March 2nd by this community caretaking team. Again, we ask the court to draw an adverse inference against the state. They carry the burden of proof on that warrantless search. One of the only report that was contemporaneously generated from that search is missing, has not been provided, has not been given to the district attorney, has not been given to Deputy Gabriel. That is a Brady issue. That is a due process problem that is still ongoing. That's a significant issue. On top of that, though, we do know by their own admission that they trespassed on the property and that what they said in that search warrant affidavit is misleading, deliberately so. They imply in the search warrant affidavit that it was observed, the shovel was observed from the vantage point of the driveway, when we know that they actually were inside of the driveway, inside the garage, and that they had made entry into the home. That's another critical false statement. And again, because so much of this also is dependent on the illegal searches that preceded it, it is critical to the probable cause decision that the magistrate made. We should have been allowed to go into those things. The warrantless arrest. Your Honor, the warrantless arrest is a very significant thing. You've seen the video. You've heard the testimony. There was no probable cause to arrest Andre McDonald. There was no justification. That's made evident by the fact that Bexar County had to let him go. And then they enlist his commanding officer to pursue a CDE at SAMC. We know, and our exhibit we just attended this morning is correspondence from Commander Chedelat advising that he visited with Andre that morning and that he appeared fine. He had no concerns for his mental health. What changed? What changed was he got arrested in a very violent way at Nagel's gun store, having walked out of the premises without a gun, irrespective of whether he paid for it. We can't ever separate that out from Chedelat's decision. So whether
I guess he met with him earlier that morning, and he already knew that he was going to purchase a gun, or he actually told him what to go find a website, go find internet access, and they already knew his garage was, damaged, and they were going to help fix it, and they weren't concerned to take him to a mental at that time, other than just the arrest itself and the taking.
Right. He tells them the garage is busted. Where's the repairman's number? He gets the library information. That information is already flowing into Chedelat's mind. He's comfortable writing correspondence saying Andre's fine. The difference is the arrest. The arrest triggers this. So whether the whether the note was found on his person incident to lawful arrest or our condition unlawful arrest when he was taken down in Nagel's, or whether it somehow did magically not get found until it was put in property at SAMC, we would contend that unlawful arrest, it makes the note the fruit of the poisonous tree that should be suppressed under either theory.
I'll let you finish up, because I did ask a question, but your time's up. I'll let you finish up your closing.
Thank you, Judge. I appreciate it. I'm going to try and honor that. If I could just have maybe 10 more minutes. I'm working on being more brief. Every day of my life I'm working on it. It's just hard for me. If you could bear with me, I won't try your patience.
Okay.
Under either theory, right? Under the arrest theory, it's not a lawful arrest. There is no search incident to lawful arrest that they can rely on. Under their contention, the problem is not cured. The CDE we maintain was an unlawful detention. It violated DOD policy. We've had testimony about what the DOD policy is. The requirements of good faith by the commanding officer have not been satisfied. Again, it would be the state's burden to put on evidence to prove that there was some justification under the DOD policy. They have not. They've elected to put on the least amount of evidence possible to support that contention. And even if the CDE detention was valid for some reason, if in fact the court finds the note was located in the inventory at the end of March, when Bexar County went back to go and retrieve it, they did so without a warrant. They went into Andre McDonald's private confidential medical files. The front cover of the exhibit the state offered reminds the viewer that what you're holding is protected by a federal privacy act. There are DOD directives on the fact that only the least amount of material necessary to convey to the commander his readiness and fitness for duty can be disclosed out of his medical personnel file once he goes in for a CDE. And we're just going to let Bexar County waltz in and take photographs and take the note that has been placed here by the witness's testimony for medical purposes. There's HIPAA concerns, there are federal privacy concerns, there are DOD regulatory concerns. None of those were honored, and the witness acknowledged that the taking of the note does not jive with her subjective understanding of the privacy rights of the patient. And I don't think that they jive with society's privacy rights for the patient. We have a reasonable expectation of privacy in our medical file.
The state always presents medical records in all their cases. Are you saying they usually identify that with a warrant, and this is the difference, or?
Well, in many situations, medical records are required. They can be acquired by subpoena in some instances, and oftentimes when HIPAA is implicated, the proper procedure is to first seek court order. That court order has to represent under HIPAA that the patient has been advised that a subpoena is issued for their medical records so that they can timely object and try to quash the subpoena. That procedure was not followed. There was no warrant obtained. We provided the court with some material in the brief with respect to Court of Criminal Appeals cases involving medical records as they apply to blood draws in DWI investigations. And the court has recognized that things like HIPAA, things like hospital privacy regulations, do create a subjective interest in subjective privacy interest that society is willing to recognize that would necessitate a warrant for the acquisition of that information. We're getting away from the idea that Carpenter has begun to do this for us. In Carpenter, we found a first opportunity to say third-party doctrine is not a universal panacea for warrant requirement issues in the historic cell site location data arena. And what we're talking about in Carpenter is what are the societal expectations of privacy? How much of this more global pool of information about us are we willing to let a third party hand out willy-nilly to whoever wants it? If my cell site location data is private and third-party doctrine can't fix an issue like this, why wouldn't my medical file be private? That contains a far more intimate snapshot of who I am than where I've been or what I've Googled on my phone. They needed a warrant to get into Andre McDonald's medical file. They didn't even try. It doesn't appear that they even acknowledged that that was a problem. But it's a warrantless search of a protected area of his personal medical information, and it was asking the hospital to do something that they would never have done under normal circumstances.
When did they get these records? Was it a year or 2 years later?
No, it was the end of March of 2019, I believe. It was March 28th. I could be wrong about the exact date.
Okay.
But they came back to it after the fact. The last thing I want to talk about with the court specifically, unless the court has questions about the emergency doctrine, in which case I can come back to it. I've submitted a supplemental brief about it. I don't think it applies, but if the court has questions about it, I'm happy to answer them.
Thanks, defense counsel. It's worth maybe no time. Okay, state.
Can I just say one last thing?
No, I got plenty of your arguments and plenty of your briefs and responses to each case response and back and forth, and it's over 21 minutes now. Go ahead.
I would just object that I haven't had a chance to speak about the second
I didn't
cell
have to
phone
do any
search.
argument at all, but I did. Go ahead.
Thank you, Your Honor. First, I just want to say that he calls it a warrantless search when Carol Gambar and Elizabeth Counsel went into the McDonald's home. But it can't be a warrantless search because the warrant requirement does not apply to private citizens. They cannot search something without a warrant because there's no requirement for them to get a warrant in the first place. So the only way the exclusionary rule can be triggered by the actions of the private citizen is actually the defendant has the burden to prove that the private citizen committed a crime, a criminal offense. The only criminal offense that they have alleged that Carol Gambar and Elizabeth Counsel committed that day is criminal trespass. Well, we all know that you have to do criminal trespass without the effective consent of the owner. Carol Gambar had the effective consent of Andreen McDonald, the homeowner, her friend. She had her effective consent when Andre McDonald told Carol Gambar that if I ever go missing, Andre did it, come and find me. In addition to those issues that she knew about their marriage, she had concerns because Andreen always answers her phone. She has these migraines. She always responds to her friends and her family when it's a work-related issue. I know, I've joked with co-counsel that if I went missing for a couple of hours, nobody would come looking for me and be worried about me. But we cannot look at it in a vacuum. We have to look at it with the knowledge that Carol had from Andreen herself. She had concerns. She knew that something was wrong with her friend, and then when she went into the home, her concerns were cemented with the fact that Andreen was not there, and instead there was blood. So I would hope that any of us would have a good enough friend like Carol Gambar that would come and would be willing to look for us, would be willing to find us, and not say, you know what, I can't go. I can't go to my friend's house. I'm worried about him, but there's nothing that I can do, right? And so she had the effective consent. So therefore, the 3823 exclusionary rule for other persons' actions, they have not met their burden. The court does not have to exclude any evidence that came from Carol and Elizabeth's entry into the home. So the next step that they tried to say is that, well, okay, Carol Gambar was working under, the Fourth Amendment does apply because Carol Gambar was working as an agent of Brian Ray. But, okay, let's say that Brian Ray was working in his capacity as a SAPD detective. What did he tell her to do? He told her to call the police. So his direction to her was to call law enforcement, and that is exactly what she did. And then when it comes to Maureen's consent, the state's argument is not to say that Maureen's consent attenuates the taint of an illegal search, because our argument is that there was no illegal search. There's nothing to attenuate the taint of. We're only saying that Maureen allowed Philberto Gonzalez to come into the home where she was a full-time resident because she was concerned for her daughter. She brought him into the home. She walked him around. She showed him things that were his concern. Because they had, because as your court has said, as defense counsel said, Andreen was only been missing for a couple of hours. So they needed to secure why they were concerned. They needed to show him why police needed to get involved and take this emergency seriously. And that's what they did. I'm not going to relitigate the Franks issue. I think your Honor has heard enough about that. So moving on to the entry into the garage. Yes, and the state is conceding there was no warrant when the officers first entered the garage. But what they had this emergency doctrine, right? They had this broken garage. The garage had changed since the 12 hours prior when law enforcement was at the home. They still had a missing person. We can't look at the garage alone. They still had not found Andreen, right? And then meanwhile, they're surveilling Mr. McDonald. They have this broken garage. What is the police supposed to do? They're still worried about Andreen. Maybe she's in the vehicle. Maybe she's in the garage hurt. And that's all they did. They took the steps to assure that Andreen was not lying there, sick, not hurt. They checked in the vehicle. They checked in the garage. They went around the home. They went in the home. They called out for anyone. When they got no answer, they immediately left the home. They took nothing from the home. They did not search the home. They were simply there to see if Andreen was okay. The next thing is the Naples. Again, we're conceding that it was a warrantless custody. We're not trying to say that Mr. McDonald was not in custody when they took him down at Naples. But again, circumstances had changed. We had the broken garage. Andreen's still missing, and he purchased a firearm. The officers, when they were surveilling him, they didn't make him go to Naples. If he would have gone to HEB or gone to the gas station, they just would have continued to follow him. But what were they supposed to do in that moment when he purchased a firearm? They had his safety at hand. They had other people's safety at hand. They had to take him down. When he was, they took him down to have him evaluated for emergency detention. Person buying the firearm under these circumstances, suicidal
Didn't
possibility.
one of the officers say he wouldn't have arrested him unless it was told by his higher up?
I think he said he didn't know why they told him to take him down because he didn't have the full circumstances. Remember, Sergeant Tolman was just head of the surveillance. He didn't have the full information of whatever command was doing, so he was taking the order. So I think that's what he said was the why, right? Because remember, they're working as a team, so there are members of law enforcement that have the full picture of the information as to why the takedown happens. And again, Your Honor, this is, we have the benefit of years of reflection. This has happened instantaneously, right? The information about the garage, the fact that he's going to the gun store, this is all happening in real time, and the officers are doing the best that they can with the knowledge that they have at the time. So they take him down, they have him evaluated for the emergency detention. He doesn't meet the criteria. And I know Your Honor has some concerns for that, and it makes sense, right? The thinking is like, but for the interaction at Naples, the lieutenant colonel would have never gotten involved in taking him down to the BAMC. But flip it around. What if Mr. McDonald was not a member of the military? When they would have had the emergency detention and found that he didn't meet the criteria, BCSO would have let him go. Sure, they probably still would have followed him and surveyed him, but they would have released him. So it's but for the fact that he's a military member that he was taken down to BAMC and then put under the boxer by his commander's order. Now, if anyone's been a member of the military, you know that your privacy interest, your privacy rights as the regular citizens, it's not the same. You're given orders about where to go, where to move, where to live, all of the time. The commander tells you to do something from basic training, that's what you do. And that's what Mr. McDonald was doing, was following orders of his commander, and then they did the boxer. He was evaluated by the doctor. The doctor did the independent review as to whether he needed to stay. And he did. And that's whenever his items in his pocket were found for the inventory search. That's really all I have. You have our briefing, but I just want to just restate that they have the burden to prove. I mean, basically, their entire argument comes from the actions of Carol Gambar. And if we're to say that Carol Gambar is not allowed in our society to go check on her friends, because remember, the exclusionary rule is about deterrence. It's about deterring bad behavior. What is the bad behavior that we are trying to deter here? I would hope that Carol Gambar could get to look for her friends. Thank you.
Thank you, counsel. We're hearing enough witnesses, and we've read enough of your briefs and response to briefs and response to responses, and heard your arguments, so feel comfortable making a decision now. As far as illegal arrest, I'm going to go ahead and grant the defense a motion to suppress on that. As far as this written note where he's, y'all know what note I'm talking about, where he's asking me to put him down, he's a knife, gas cans, flashlights, batteries, black bags, and I'm also going to go ahead and suppress what the defense attorney further to, he states it's at 19, the medical records. As far as the rest of the motion to suppress is at 9. Anything further?
Your Honor, we understand the court's ruling. We appreciate the ruling, especially on the illegal arrest and the note. We would, of course, take exception, and we will be asking to make our bill with respect to the denial of the remainder. The question, I guess, that I would have is that the conclusion of the court that the note is suppressible that is suppressed raises issues about things that flow from the acquisition of that note. Other pieces of evidence were obtained and other pieces of evidence were deemed to be significant because of the note's discovery. And that's something that I think we need to suss out. I don't know how exactly we will be able to develop that without taking up an even longer hearing, but in the course of trial, we may have testimony heard where it's indicated that the reason something was found is because they found that note.
I'm not saying that I don't believe at all that the officers found it and put it back in the argument about that. I'm suppressing the legality of the search and then how they got this medical record, but I'm not buying at all that they saw it, they put it back in there because they knew they were doing something wrong, so I'm not believing that.
Okay, so factually, you find with the state that the note was seized at the end of March.
Yes, correct.
But you're suppressing it nevertheless?
Yes.
Okay. To the extent that we hear in trial anything about actions undertaken because of finding the note at the end of March,
I'll reconsider.
we would ask you to just reconsider at that time.
Yes, I'll do that.
Thank you, Judge.
Okay, well, jury's coming back at 9, anticipate start 9:15, 9:30. I do have, if y'all want to approach, we can turn this off on the live stream. It's about